It is now 4 minutes after 8. Right here on Morning Express, it's time for us to look at stories making headlines. Now, the country is staring at a potential constitutional crisis as President Uhuru Kenyatta ponders over his next move following the directive from the Chief Justice David Maraga to dissolve Parliament for a failure to enact the gender parity law. But just how did we get here? And what political and legal intrigues will dictate President Kenyatta's next move?
Vicious, potentially divisive, and globally watched pre-2013 presidential campaigns were already at a fever pitch when Professor Githu Muigai, then only on his second year as Attorney General, petitioned the Supreme Court on, among other issues, resolution of presidential election disputes, timelines for any likely repeat presidential poll, and the not more than 2/3 gender law. Former Chief Justice Willie Mutunga, in the sole dissenting verdict of the bench, warned against expecting Parliament to enact the gender law after the 2013 polls,
arguing that the 2/3 gender rule requires progressive realization, flies into the face of this history of struggle by Kenyan women.
So what could now dissuade President Uhuru Kenyatta from dissolving the National Assembly and the Senate, as advised by Chief Justice David Maraga? Perhaps the first on his entree will be analysis of the legal implications of a petition the National Assembly Speaker Justin Muturi-chaired Parliamentary Service Commission is due to file at the High Court. In the petition, Parliament, it is expected, will for a start be seeking conservatory orders barring the President against acting on Maraga's advice during the trial period. Analysts argue that while this may for a while buy Kenyatta's handlers more time, the perfect arsenal for the current Parliament to stay on despite its unconstitutionality on the basis of the gender question will be in the delay tactics occasioned by unexpected prolonged trial, with the final High Court verdict also being subject to further appeal at the Appellate Court and subsequently the Supreme Court. A stalemate that could prolong to the next polls in 2022.
Courts have interpreted time to mean reasonable time, a minimum of 14, a maximum of 21 days. The President must therefore act within a period of 21 days and dissolve Parliament.
When you look at it, he's doing it too late in the day. Because when the Chief Justice retires in 3 months, the process of getting the next Chief Justice comes into place. That very next Chief Justice has to be vetted by Parliament.
Still, critics have lately accused Kenyatta of giving a deaf ear to the judiciary in a bad blood recently escalated by Kenyatta's defiance of several court orders and failure to appoint 41 judges already approved by the Judicial Service Commission, a rather infamous trait perfected by legal and political actors critical of Supreme Court advisories. It is therefore not lost on those who claim Kenyatta could again ignore the Maraga advisory, the legal implications and corresponding outcry notwithstanding.
Launching the BBI.
And then there is the Building Bridges initiative, widely marketed by its proponents as the masterstroke to cure all the country's legal and political ailments. Some leaders now citing the Maraga advisory as the perfect illustrator of the inevitability of a constitutional referendum before the 2022 polls.
This should be a referendum question. It should now be taken back to the people, and the people should be asked, do you still believe that you want to have the 2/3 principle still enacted or having it in our law?
If the President ignores the CJ's advice, there are two consequences. Effective today, any laws passed by the National Assembly and the Senate are of no effect. They are null and void ab initio.
Politics certainly is a game of wit, skill and strategy, but with legal questions now also at play, Kenyatta faces a rather complex gamble as Kenyans await his next move. Murimi Mwangi, KTN News in Nairobi.
Now, still on that, Chief Justice David Maraga's advice to President Uhuru Kenyatta adds to the list of one-of-a-kind moves and statements by the CJ that have put him on a collision course with the president. Maraga has on several occasions trained his guns on head of state over his handling of the judiciary. Our senior reporter Rita Tinina traces the frosty relationship between President Kenyatta and CJ Maraga.
For the men at the helm of the two arms of government, the relationship between President Uhuru Kenyatta and Chief Justice David Maraga has been a strained one. The 1st of September 2017 Supreme Court ruling may have laid the ground for the bumpy ride.
That the presidential election held on 8th August 2017 was not conducted in accordance with the Constitution and the applicable law, rendering the declared results invalid, null, and void.
That ruling clearly angered the president.
We have a problem with our judiciary, but regardless, we respect, but we shall revisit.